Welcome to FDA Imports, cross-border compliance with attorney BenjaminLEngland.
Hello, everyone. Welcome to FDA Imports, cross-border compliance with attorney BenjaminLEngland. Ben is the founder of FDAImports.com and a former FDA regulatory counsel who helps companies worldwide navigate the complex intersection of FDA oversight and international trade. I'm Sean O'Connor, and today we're talking about customs post-entry audits, specifically CF-28s, CF-29s, and why issues can surface long after a shipment clears the border. So stick around for this one. Ben, good to see you.
Hey, great to see you, Sean. Thanks for having me.
Now, I'm guessing that many importers assume that, once a shipment clears customs, we're done, right? But from a CBP standpoint, why isn't that always true?
Yeah, there's a couple of pieces to that. One is when you make entry, when you bring something into the United States, you're gonna get custody of those goods before they actually are unconditionally cleared by customs. So customs is going to let you have them, but they're not finished. And this is particularly true if it's FDA regulated or even some other agencies, the regulation as well. But FDA is sort of the big gorilla in the space with FDA, with customs here. So you bring the goods in, you take custody, it's in your warehouse, and customs has released it to you conditionally. Okay. That means that there's other things that have to happen for that to become an unconditional release. And so we're going to set that aside because that's about how customs uses a bonding process in order to let you take custody of the goods, even though FDA is still looking at it and customs may even have questions about it, right? And so 30 days after FDA is finished and does their release, and that could be the same time customs does this release. So it's just 30 days, right? 30 days after both agencies have released, customs, the customs release becomes unconditional. And that's when people think, oh, whew, done. Right? Well, no. And here's why. Customs is regulating far more than FDA. Well, let's put it this way. They regulate very different things. FDA is mostly worried about the substantive compliance of the product with respect to safety and efficacy. If it's a drug, wholesomeness, labeling, not saying things that are untrue of the product itself, whether it's a cosmetic or food or drug or device, whatever. They also care about the manufacturer, how the manufacturer made it, how it was designed, right? This is all about the product itself. Customs cares about the product too, but they care about it primarily along the lines of how much money should I collect for it? Duty, right? So it needs to be properly classified in order for them to figure out how much duty, and the country of origin is relevant because the duty from different countries is different. Okay. If I'm bringing something from Mexico, it's not the same as I bring it from China. And so country of origin, the classification of the goods, are the goods counterfeit, right? Are they legitimate product, right? Are they counterfeit? Are they somehow in violation of some intellectual property? That's substantive, but it's about protecting the brands of the product and the brand owners. So with customs, a lot of that stuff is available. Customs can do an examination just like FDA can, but customs, when they do exams, they tend to be doing X-ray exams looking for dirty bombs. They tend to be looking for smuggled goods, or they're looking for drugs and looking for dope and guns and people, right? That's what they're looking for in the smuggling operations. And so that's happening before entry. That's actually happening when the goods are arriving physically. After the goods come and are arrived and then entry is made, customs can do examinations. They can test it further. They can detain it in order to do further inspections. Lots of things, like investigations. But eventually they're going to release the cargo. It's going to go to you. And then people think, well, now I'm done everything, the gauntlet, right? And the answer is no. For another 7 years, the government can go back and figure out whether you actually have the right declaration or not, whether you have the right HTS code, whether it really, did you pay the right duties? Did it really come from there? Did you in fact include the fact that there's some like additional financial benefit that you received from the foreign supplier that may be a part of value, right? All sorts of things. Well, that kind of thing will rise after the goods have already come through, they've been entered, and customs issues you a notice. And it's called a CF-28, Customs Form 28. And it's basically they're investigating information related to specific entries, all right? It's going to be entry by entry. You might get a CF-28. And in that CF-28, customs is going to ask for specific details. They tend to ask very consistent questions depending upon what the issue is, right? If it's about valuation versus about origin, versus compliance of the product or the foreign manufacturer, whether there's a forced labor risk, right? There's all sorts of things that they might be investigating. And they're going to issue a CF-28. That's the time when you're supposed to have the answers. You're supposed to have the answers to these questions when they issue the form.
Got it.
Because they're only going to ask you questions that are about the compliance of the goods that should have existed at the time of entry. So you ought to have the documents, right? And if you don't have the documents, you can have a problem. They're going to give it 30 days, basically. Customs is going to give it 30 days to respond to that CF-28.
And so what about the CF-29? How do they differ? The customs, I'm assuming, and they must have different, job descriptions, so to speak.
Yeah, right. So the CF-28 is when the government is looking into something, right? And they think that there might be something there. It could be that in the industry, they've started to see something that gives them some concern, and they go track down entries of other importers, and they're doing it sort of like an informal, they're just checking and determining that you have compliant documents to support a certain claim. A CF-29 happens when the government is serious, right? A CF-29 is that they've initiated an investigation. Now, the difference here is that by the time you get to a CF-29, you are running the risk of penalties. If they find out, like a CF-28, you can fix something, you can correct it, you can say, I'm sorry, it was a mistake. You can do what's called a prior disclosure. You can tell customs, hey, I think I made a mistake here. And you can do a prior disclosure and tell them what that mistake was. You can do a request for advice. Asking customs, this is what we think, this is what we did, but we think we might be wrong. Maybe it's this, and you ask them. That happens in the CF-28 phase, or it happens before a CF-28. It's got to happen before a CF-29. Because if customs issues a CF-29, they're already in the investigation phase. And if they're in the investigation phase, and it turns out that you're wrong and they're right, now you run the risk of paying penalties. And that is not just duty, it's duty times 2, times 3, maybe times the value of the goods. And so depending upon the degree of culpability that they think that you have in having screwed that up. So the two forms they mean different things, because one of them is inquiry and the other one is investigation, and they're in a formal investigation.
Vastly different, but very close together number-wise.
Yeah, right. Get that wrong accidentally. Yeah.
So what kinds of issues might trigger a post-entry audit? Is it valuation, classification? You mentioned country of origin, or, is FDA involved? What sorts of things come into play?
Yep. So it can be FDA regulated goods, obviously. It's sort of not dependent upon another agency's jurisdiction. But it could be that the questions that they're asking implicate FDA jurisdiction as well, right? If they ask, for instance, whether or not the goods actually came from country X, which is where you said they came from, and those goods, if they were to come from country Y, would be on import alert, right? On an FDA import alert. And it turns out they actually came from country Y, right? Now you've got two problems. One, you have a declaration problem, right? A misdeclaration problem. But the other thing you have is you got goods that were imported that shouldn't have been imported because of another agency's considerations, right? So those things can easily cross over. But yes, so valuation, right? Are the goods worth $100,000 or are they worth $50,000? Big difference, because if you're paying duty based upon a percentage, right? So 1% of 50,000 is different than 1% of 100,000. And that's how duty is calculated. Free trade agreements, right? If it comes from a country within the government from which the U.S. government has a free trade agreement, then it might be duty free. But if it comes from the neighbor, it's 10%. Okay. Yeah. But it doesn't mean it was shipped from that country. It means it's from that country of origin, which means it meets the origin definition for that country, which may or may not include being shipped from that country. Like, because I can make something in Israel and I can ship it through the UK to the United States. It doesn't make them UK goods. They're Israeli goods, right? So now that's interesting about, like, for instance, if I'm an importer and I'm declaring a certain value, a certain classification, this is what it is, the goods are, and it came from a country with which we have an FTA, and consequently I should pay zero duty, irrespective of the fact that the goods are worth $15 million, right? but I pay zero because it's coming from a country with which we have an FTA. The government expects that you have all of the evidence necessary to prove every one of those facts when you make entry. All right. So the importer is supposed to have those documents already. So when they come back with a CF-28, they expect you to respond within 30 days because after all, you're supposed to have the documents, right? And so if you don't have them and you have to go back and say, can I please have a couple more days because I'm going back to my manufacturer to get proof of origin, they're going to be saying, well, then how did you make an FTA claim, right? Right away, they're starting to scratch their head. So, you're supposed to have, it's anything related to customs admissibility, application of duty, whether there's any restrictions like related to intellectual property. Though customs is going to focus on its jurisdiction. It's usually not going to use a CF-28 to investigate an FDA issue, but FDA issues can arise in a CF-28 investigation.
You mentioned earlier this idea that, the goods have come through and been released, but it was conditional and, years can go by and then it can catch up with you. I'm wondering how far back can customs look when reviewing entries? Like what surprises companies the most about that scope of those audits?
Sure. Customs can go back and if there is evidence of the fact that there's a question about classification or something that affects duty, they can go back 7 years into all of your entries. In fact,
that's like a statute of limitations.
Yeah, exactly.
The customs.
Yep. And importers are obligated to maintain records for that period of time for that very reason. So you've got a certain record keeping obligation in order to make certain that customs can fulfill its investigative mandate, right? Its authority to investigate. So if you make a mistake on one HTS code 100,000 times, that's 100,000 violations, right? So, if each of them cost you $5, that's $500,000 if they only charge you duty. Now, I guarantee you they're going to charge you duty. The one thing that they never don't do is charge you duty. It's like the IRS, right? I mean, you might be able to convince them not to charge you interest, but you're paying the tax, right?
Yeah.
And it's the same with customs and duty. They're not going to get. It's extremely rare for them to let you off at not paying duty. The question is it going to be more than just duty, like with a penalty action? Is it going to be 2x, 3x, or maybe value of goods, right? 10% of $1 million is $100,000. That's duty. But if it turns out they think your culpability is very, very high, that you were trying to avoid duty intentionally and there's some fraud involved, they can come after the million, right? So that's value of the goods. They could come after domestic value of the goods. It could be that the goods in the U.S. are worth $5 million, but at the border they're worth $1 million, right? So it depends on how bad they think you are. And I would say you better make sure you make your declarations that are correct, and you better have your documents to prove it. And if you get a CF-28, you got to read that thing very, very carefully because they're asking for some very specific information, and they expect you to have it pretty rapidly. So you want to be prepared. All of the declarations you're planning to make, you need to have documents for it. And when they ask, I would recommend you get somebody to look at it before you submit it to the government. The same way I would rely on an accountant before I submit a CPA before I submit my taxes. Even though I'm an attorney, I'm not going to practice tax law. In the same way, you might be an importer, but you might not want to practice customs law.
Yeah, that makes sense. You mentioned FDA related issues. I'm wondering how FDA-related information sort of factor into the post-entry reviews. Like, in what situations would customs loop FDA back in after clearance has already taken place?
So where I have seen that happen is going to be in a place where the agencies are already working together because they have anxiety about particular kinds of products. And I'll give you an example. Kratom, or pronounced kratom. It's Microgenus speciosa, right? You see it, CBD, kratom, and all these shops, right? Smoke shops. FDA's view about kratom is that it's either an unapproved drug, or it's a dietary supplement that's a new dietary ingredient, or it's an additive in a food that's not generally recognized as safe, right? There's like their view is that you can't do anything with it without it being illegal. That's FDA's position.
It's sketchy. Right? It's sketchy. It's on their radar.
Right. I'm just telling you their opinion, and I know that because I've challenged them multiple times. I've been able. There's times I can get kratom released by the FDA, but it's because of the facts. It's in the law. But But if customs is worried about kratom and FDA is worried about kratom because it's being declared as things that it's not, right? Well, that's a false declaration. And so if customs finds it in some CF-28 operation, or they find it in some, in some investigation, then they're going to bring FDA into it. If it's a drug and it looks like it's a counterfeit, they might bring FDA into it because FDA has an Office of Criminal Investigations that investigates counterfeit drugs. I used to work for OCI. I used to investigate counterfeit drugs with FDA. So they might, like, some of these things are sensitive enough that they might bring in FDA. If it's just, it came from country A instead of country B, they might not think to bring FDA in, even though it might be relevant. Like, it really depends upon the degree to which the officer at customs is sensitive to the FDA questions.
Continuing with that, just since we're talking FDA, for companies importing FDA regulated products, on the regular, what systems or internal checks help them reduce these post-entry audits, the exposure that comes from that? What do they need to do, I guess, to get ahead of issues before they arise? What's your recommendation here?
First of all, you got to know what you're importing, and you have to know who you're importing it from, right? It's really mostly about information. It's also making certain, if you think of it this way, that, probably the most critical document in an international transaction is the purchase order, because the purchase order is the thing where I, as the importer, am telling you what you're supposed to deliver to me. It matters because if I'm going to sue you, it needs to be in my purchase order and you have to have accepted it. Okay? Damages that arise from you failing to deliver what you agreed to deliver because it's in my purchase order are going to be, you're going to be liable for under contract law. So my ability to enforce against you is the purchase order. The other thing, though, is the purchase order sets essentially the regulatory requirements, right? It has to have this registration, it has to have that USDA permit, it has to have this this FDA clearance, it has to have this TSCA form under EPA law. It has to have all these pieces, and I build that into my specs, into that particular document, so that when it comes here, I have a reason to believe that it's going to get in. Now, the second question is, what happens when customs starts asking me questions, right? Well, I could have said, well, look, I told Sean that this is what I need in my purchase orders, to go talk to him. And they would say no, because Sean is in another country and you're not. I'm not. I'm here, right? Yeah. So they're going to talk to me, and they want me to show them the documents. And so the answer is, I need to not just have a purchase order that's solid. I have to have the documents to prove that you've met those conditions, right? And if it's about classification, I need to have the documentations about classification. If it's about a free trade agreement, because we've built that into the agreement, I expect you to get it from certain countries of origin, because I want to have the benefit of that FTA. And so I'm going to put that on you. Well, I don't successfully get it on you, right? Ever. When customs says, it stays on me. And I have to get from you the documents I need to prove to them that I did it. So that's anything FDA regulated or not FDA regulated.
Yeah, the documentation, the clear PO. That's
they say in the government over and over that if you didn't document it, you didn't do it, and it's not more. It couldn't be more true at the border.
Right. That's right. I thought it was, if it's not on the gram, it didn't happen.
Oh, well, there's that too. Right.
Listen, Ben, we're out of time. Great to see you. Great conversation as always.
Yeah, great, Sean. Thanks for letting me talk about these crazy investigations.
Yeah, you bet. You bet. Well, that's it for today's episode of FDA Imports Cross-Border Compliance. If your company has received a CF-28 or a CF-29, remember, big difference, or you want to reduce the risk of post-entry issues tied to FDA-regulated imports, visit FDAImports.com to connect with Ben and his team. And be sure to like, subscribe to this show, and leave a review if you found this episode helpful. I'm Sean O'Connor. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.